Welcome back to TicBite NC. I'm Todd Edwards, and parts, if you've stayed with me through parts 1 and 2, thank you. We've covered a lot of ground. In part 1, we looked at what Virginia lawmakers actually passed. And in part 2, we talked about what Supreme Court decisions the New York State Rifle and Pistol Association versus Bruin and why it changed the way courts evaluate the Second Amendment cases. If you have not watched parts 1 and 2, pause this video, go watch them, and come back because you're going to want to watch those two to build on this. Tonight, we're going to bring those two stories together. This is where constitutional theory meets the real world, and this is where legislation meets litigation. This is where judges, not politicians, will ultimately decide whether some of Virginia's significant firearms restrictions can stand. Let's face it, when people pass law, a group of people get together and write down some ideas, and they say, you know what, these are good ideas. Let's make everybody abide by these ideas. And that's how we get laws. Laws don't arrive in a fax message from God or something. They're not divinely inspired. They're just a group of people get together and write them down. So that's why we have a 3-part government system. The judges are going to get together and talk about it now. July 1st was supposed to change everything. Virginia lawmakers passed a package of firearms legislation that supporters described as a majority public safety initiative. The centerpiece was a law restricting the future sale, manufacture, importation, and many transfers of firearms that fell within Virginia's statutory definition of assault firearm. The legislation also restricts many future sales and transfers of magazines capable of holding more than 15 rounds. If you listen to part 1, you know these weren't just bans on one specific rifle. The laws use definitions based on features, certain semi-automatic rifles, certain pistols, certain shotguns, and certain magazines. The law was scheduled to take effect just a couple of days ago on July 1st, but something happened before that date arrived. The courtroom doors opened. The lawsuits arrived almost overnight. One thing that stood out wasn't simply that lawsuits were filed, it was how quickly they were filed. One of my friends was in the courtroom to watch it happen. Organizations representing gun owners, firearm dealers, manufacturers, individual citizens all challenged the law. Some lawsuits relied primarily on the United States Constitution. Others argued that the law violated protections found in the Virginia Constitution. That tells you something important, that the plaintiffs weren't arguing that they simply disagreed with the legislature. They were arguing that the legislature had crossed constitutional boundaries, and that's a different argument. What the plaintiffs are saying, I'm going to simplify their position. The plaintiffs generally argue that semi-automatic rifles such as the AR-15 are among some of the most commonly owned rifles in America. Millions of people own these rifles are law-abiding citizens. They're used for recreational shooting, competition, predator hunting, home defense, and in some states, they're used to hunt various game species. In my home state of North Carolina, we can deer hunt with them. And there's been many deer that have been taken with a .223 caliber weapon. They don't have any recoil. A young person can easily shoulder and fire that weapon, with proper adult supervision. But their argument's straightforward. If these firearms are common, lawful use, then the Second Amendment protects them. The same argument extends to magazines. Many magazines hold more than 15 rounds or standard factory equipment that comes with commonly sold firearms. That's true. If you buy a common semi-automatic rifle, they often come with 30-round magazines. The plaintiffs argue that because these items are commonly possessed for lawful purposes, the government bears the burden under Bruin of demonstrating a historical tradition supporting restrictions of this kind. So what is Virginia arguing? The Commonwealth's position is different. Virginia argues that the challenged firearms have characteristics that justify Let me start over. Virginia argues that the challenged firearms have characteristics that justify regulation. Virginia thinks they look scary. The state also argues that history contains examples of governments regulating particularly dangerous weapons and that modern legislature may address modern public safety concerns within constitutional limits. I want you to notice something. Both sides are talking about history. That's Bruin at work. 10 years ago, the arguments might have been focused mostly on crime statistics and public policy studies. Today, both sides spend an enormous effort discussing historical laws and traditions. That shift happened because the Supreme Court changed the legal framework with the Bruin case. Then came the injunction. Let's talk about something many people misunderstand. A preliminary injunction is not a final victory. It's not a defeat. Think of it as pressing the pause button. Like this. I'm going to press the pause button. All right, I unpaused it. The judge looks at the evidence presented early in the case and asks several questions. Have the challengers solved a substantial legal question? Could they suffer harm that cannot easily be repaired if the law goes into effect? Let's think about that for a minute now. If the law went into effect, could the plaintiff suffer harm? So your rights would be restricted. Can they unrestrict your rights? No, I mean, that period of time that they were restricted, it couldn't be undone. So sounds like that fits. Does the balance of equities favor temporary relief while the lawsuit proceeds? If those standards are met, a judge may temporarily stop enforcement while courts fully consider the issues. And that's exactly what happened in one of Virginia's assault firearms cases. A circuit court judge issued a preliminary injunction preventing enforcement of the challenged law while litigation continues. Now, that injunction immediately became one of the biggest Second Amendment stories in the country. It was on every channel that talked about Second Amendment. It was everywhere. But remember, an injunction is temporary. Appeals follow, and higher courts review the decision. The legal process continues. Here's something else to consider. Not every judge agreed. There's another point that's easy to miss. Not every trial court reached the same conclusion. And in another challenge, a different judge declined to issue a preliminary injunction. Why does that matter? Because reasonable judges sometimes interpret the law differently. That's one reason appellate courts exist. When lower courts disagree on important constitutional questions, higher courts step in to provide uniform guidance. That's how the judicial system is designed to work. Why do appeals matter? Many people think a trial judge settles the issue. Unfortunately, usually that's only beginning. Cases involving constitutional questions often move through several layers of review. State appellate courts, federal appellate courts, sometimes both, depending on the claims involved, and occasionally the United States Supreme Court. And that's exactly true when courts around the country begin reaching different conclusions on similar laws. And that's why I say Virginia's not standing alone on this. Virginia is not the only state defending restrictions on semi-automatic firearms. Several other states have enacted similar laws. Some have survived legal challenges, others have been blocked. Still others remain tied up in litigation. At the same time, courts across the country are wrestling with the same constitutional question. Should Bruin apply to modern firearms regulations? Those differing decisions are one reason the Supreme Court has agreed to review challenges involving assault weapons bans from other states. The answers given there will ultimately influence Virginia's future as well. Now, what does this mean for hunters? Let's bring it back home. Most of the people listening to this podcast are hunters. You may hunt deer with a bolt-action rifle. You may carry a lever action through the woods. You may hunt ducks with a shotgun your grandfather owned. You might be thinking this doesn't affect you, and maybe it never will, but constitutional cases rarely stay confined to one narrow fact pattern. When courts define the scope of a constitutional right, they create precedents. Today's decision about one category of firearms may influence tomorrow's case involving another. And that's why constitutional law matters, even to people who don't own a specific firearm at the center of today's debate. This is bigger than firearms. One lesson stands above everything else we've discussed. Constitutional rights are not measured by opinion polls. Courts do not ask whether a right is popular. They don't ask whether a majority approves. Their job is to determine what the Constitution permits and what it forbids. And sometimes that means a law survives, or sometimes it does not. But in either case, the process matters, because constitutional government depends on laws being tested against the Constitution, not merely public opinion. The United States is not a democracy. The United States is a constitutional republic. In a democracy, if there are 4 people there and 3 of the 4 people vote to take everything away from person number 4, then that's what happens. In a constitutional republic, the rights of the people are written down, and the majority can't vote to take them away from the minority. That's what a constitutional republic is. So where do we stand today? As of today, the legislation continues. Some provisions have been temporarily halted through court orders. Other issues remain actively under review, and appeals are moving forward. No final decision has settled all of the constitutional questions surrounding Virginia's firearm legislation. That means anyone claiming the fight's already over is getting way ahead of the courts. This story's still being written. Now, whether you support these laws or oppose them, I encourage you to do something that has become increasingly uncommon. Sit down and read the legislation, read the court opinions, and then read the Constitution. The Second Amendment's real short. Don't rely on the headlines, and don't rely on social media posts. Social media posts, especially the comments, have got to be the least active place to get information, especially the comments. Go to the source whenever you can. An informed citizen is much harder to mislead than an angry one. Here at TicBite NC, that's what we're going to continue doing. We're going to follow the facts. We're going to look at history, and we're going to follow the law wherever it leads. I'm Todd Edwards, and thank you for joining me for the third part of this series. Until next time, take someone hunting, take someone fishing. Teach the next generation not only how to enjoy the outdoors, but why constitutional freedoms require informed citizens that are willing to understand them. Good night. I'll catch you next time.